Welcome everyone to Litigation Finance Journal's Town Hall on how litigation funders should respond to the UK Supreme Court ruling. I'm your host, John Freund. Thank you all for joining. We're really excited about this. A very topical discussion, obviously. So we're excited to jump right into it. I'm going to keep this very, very brief. There will be a link to this. We are recording of this event. You will receive that link post-event. So stay tuned for an email from me. That is all registrants will receive that recording. The format is a panel discussion followed by a Q&A with you, the attendees. So there's two ways to ask questions. You can do that through the comment feature on LinkedIn, and you can also do that by emailing me. That's jfreund@litigationfinancejournal.com, jfreund@litigationfinancejournal.com, or the comment feature on LinkedIn. So please ask your questions at any time. We'll get to as many as possible by the end. We also have memberships available. If you're interested, you can visit www.litigationfinancejournal.com. With that, I'm just going to turn it right over to our moderator, Peter Pettit. Peter and his company, Four Rivers, specialize in financial and strategic solutions for the legal services sector, advising on third-party funding for litigation and arbitration, helping law firms with strategic financial advice, and providing consultancy for stakeholders in the sector using a bespoke methodology based on Peter's corporate finance experience. Take it away, Peter.
Thank you very much, John. Good morning, good afternoon, good evening to wherever you are listening. We have a genuinely worldwide audience and also a genuinely worldwide panel today. We have an awful lot to get through, so I'm going to immediately introduce the other panelists and then we'll get straight into the questions. In no particular order, we have Neil Johnston. Neil's a practicing barrister and the founder of fundingmyclaim.com, which is a unique comparison site that connects clients, lawyers, and funders. Neil has an interest in all forms of civil and family law, and prior to entering self-employed legal practice, he was an in-house barrister for the Naval Legal Service. Tetsu Ishikawa was appointed Managing Director of Lionfish upon its launch in May 2020. He started his career as an investment banker, structuring and marketing derivative and securitization transactions at ABN AMRO, Goldman Sachs, and Morgan Stanley, as well as being a founding partner of fixed income agency broker Amias Sperman & Co. LLP. Tets has been involved in litigation funding since 2011, alongside various other business activities as both advisor and investor, including setting up captive litigation funder Sparkle Capital Limited for Acasta in 2014. And finally, Nick Rolls-Davis, who is the CEO of Lexcellent, which is the world's first globally coordinated origination networking platform for legal finance professionals using the latest technology and AI. Nick's been involved in the legal finance industry since 1999 and has led its transformation from third-party funding through litigation finance into a broad-based corporate finance offering. He is the author of Third-Party Litigation Funding, published by the Oxford University Press. What are we talking about today? Well, there was a Supreme Court ruling very recently, the Crown on the application of PACCAR Inc. against Competition Appeal Tribunal, which ruled that litigation funding agreements in which the funder's return is a share of the damages ultimately awarded to the claimant are damages-based agreements and are therefore not enforceable if they do not meet the requirements set out in the applicable regulations. Many, if not most, do not meet those requirements. So this obviously has big effect and big implications. So my first question, which I'm going to pose to Nick and Tets, is does this judgment only affect actions in the courts of England and Wales, or are there other regions at risk of similar rulings, such as Europe, Australia, or the US? Nick, do you want to take that first?
Yeah, sure. Thanks, Peter. I think the short answer is it affects England and Wales only. It's specific to the various pieces of legislation that are referenced in the judgment. And the DBA regulations are specific to litigation in the courts of England and Wales. So I think my immediate observation is it's specific to England and Wales and doesn't affect any of the jurisdictions. And I'm hopeful that Tets is going to agree with me.
I do agree, but I think there are probably kind of two side effects which are probably worth bearing in mind. So it doesn't directly affect other jurisdictions, but I think kind of thematically, there's obviously a kind of an anti-funding type lobby is probably the best way of putting it, and they might try to kind of free ride off this. It'll be interesting to see if they do. And then there's obviously the fact that as an investment jurisdiction, it may have a knock-on effect to other jurisdictions as far as the flows of litigation funding or the focus of litigation funding activities goes. But I mean, broadly, Nick, I totally agree with you. I mean, LFAs are financing agreements, and there aren't many jurisdictions where there seems to be a confusion between the difference between a financing agreement and a framework really designed for law firms' instructions with clients.
Okay, so we're pretty clear that this is just basically talking about actions that are being heard in the courts of England and Wales. And therefore, Neil, let me ask you this question. Does it therefore matter what the substantive law of the funding agreement is? In other words, if it's English or Swiss law or anything like that, does that really matter? The only issue is where the action is going to be heard.
Unfortunately, no, the litigation funding agreement will not change the nexus of the case. If it's a case in the UK, it's going to be subject to these regulations, regardless of what the funding agreement may say or deem otherwise. If it's before the English courts, the regulations will apply. It's perhaps understandable in these kind of circumstances that funders might try to think, are there creative ways we could structure our funding agreements to possibly avoid the consequences of the decision? I don't see, frankly, any way that's possible, whether they use collateral contracts outside of the direct funding agreement. The court will look at the situation between the parties in the round, and if there's share of damages, it will be deemed a damage-based agreement in the UK. So we are, I think, stuck with the consequences of the judgment as it is.
Right, okay, so that's very clear. We are talking about actions in England and Wales. So I suppose the most important part of this all is, what implications does this judgment have? And the first question I'm going to ask in respect of that is how this ruling essentially impacts the enforceability of litigation funding agreements, LFAs, in current and ongoing cases. And also, what about the LFAs from previously funded and concluded cases? So, Nick, do you want to take that one first?
Yeah, sorry.
Muted.
No, I was just a bit slow off the mark. Yeah, look, the answer is it has a pretty big impact, and it divides into a number of categories, in my view. I think, first of all, the existing arrangements between clients and litigation funders are going to come under scrutiny, and they're going to come under scrutiny for a number of reasons. The lawyers that are acting for the clients are obviously going to have to review the position. This is not a decision which is making new law. This is a statement of existing law as it has always been, and that review will need to be conducted in the light of the decision. So existing arrangements, one would hope that the ongoing arrangement between the client and the funded party and the intention to produce a successful result will be enough that that's not going to have a negative impact, and that the renegotiation or the discussion, should it be needed, is a positive one. The bigger challenge, I think, is in relation to concluded cases, and that may well cause some difficulties. I mean, I'm already hearing that there are ongoing discussions in matters that have concluded, and where an agreement that provided for a percentage to be paid to the funder is now being discussed in terms of whether that should or should not have been paid, and what the position is now. That is going to be a distraction. It's going to be an ongoing issue. And I suspect that there will be opportunistic attempts on the part of defendants in terms of challenging current and existing litigation funding agreements. So I think how that concludes, one can only guess, but the reality is it's a disruption, it's a distraction, and it's going to be an ongoing issue for a little while yet. So that would be my immediate response to how you asked that question.
So Tets, obviously you're running a fund, you've got concluded agreements, you've got agreements in place, you're negotiating new agreements. I mean, how are you proposing to deal with all this?
Well, I mean, ultimately we are in the business of funding litigation cases, so the world goes on, and we can't stop doing it just on the basis of what may be a speculative risk. But I think what we're really trying to understand here is the key risks we have. I mean, in terms of our book, it's largely been multiples based anyway, and the number of we don't have any DBA, or sorry, percentage share of the awards in relation to opt-out proceedings and the CAT. So in that regards, we're safe. But obviously, in terms of the enforceability, there are some agreements that we've had to review. But I mean, largely, I think that's a commercial conversation. Everyone's sensible. The reality is, people that we fund in the industry, not just us, but everyone generally tend to be appreciative that they've got the funding rather than ungrateful. So there is a lot of cooperation, and I agree with Nick that, generally speaking, the ongoing cases, and certainly kind of forward-going cases, is more manageable. I think, as Nick said, the big distraction will be the concluded cases. I suppose probably my position is slightly more nuanced from Nick's, in that it is a distraction, but I think it's going to be far less of a risk, partly because I think there is the reality that a lot of funding agreements have been entered into, obviously with the purpose of helping the claimants in the first place who are impecunious. If they have got damages out of it, they are certainly very grateful. And granted, there are some who may have not got nearly as much as they wanted because of funding arrangements, but there is a risk of a quantum merit claim as well on the other side. There is the fact that they've probably gone through a very long litigation process, litigation fatigue, and if it was all about money, then maybe, and some may very, very well pursue that course of action. But I think reality is, generally speaking, most will think twice about going after a funder. And if they do, the chances are that they'll probably need funding anyway. I mean, people have talked about insolvency practitioners, but if they've recovered money from a litigation, they've certainly paid them out by way of distribution. So, if they're having to go back to funders, I mean, only really funders with no interest or plans in the UK and with no consideration to supporting the industry, I think, would be willing to back those claims. So I think it's probably more a distraction rather than a real risk.
Yeah, no, I think it's a really interesting issue, and Neil, I was just interested to get your views on this, because as Nick says, there's several categories here. And I suppose what's been and gone, that may well be the subject of future litigation, but that's nothing to do with a current ongoing case. And obviously, cases that are going to be funded in the future, funders now have the ability to structure those agreements in a compliant way, and we'll come on to that. But it's the existing cases where perhaps only some of the capital has been advanced to claimants. How do you, Neil, see that as panning out? I mean, obviously the funders have some leverage here because they can still provide funding to cases. What do you see as the issue here?
I think as you say, there are two distinct key areas: concluded and non-concluded cases. For the ongoing cases, now I understand that since as early as February, a lot of funders have been looking at this in terms of contingency planning. That if the Supreme Court went the way that I think many people expected they wouldn't, and determined to do DBAs, what would they do? So I know that there has been work going behind the scenes, and it simply would need to be a situation of, if you have a funding agreement which only refers to a percentage of damages, that would need to be renegotiated, and that relies on the goodwill of the other party. But also, if it's still ongoing proceedings, you likely have leverage, because they're not going to, I suspect they're not going to want to jeopardize their main focus, which is their concurrent proceedings. So the funders maybe can speak more to that, but I suspect there's a meeting of minds on that point. If funders have agreements in place that provided for an alternative, so perhaps they had a percentage of damages or a multiple, whichever is higher, and a severance clause, even if they can't agree with the client, they may be able to rescue that funding agreement by simply severing off the percentages based element of the contract. In terms of the concluded cases, I do think there is clearly risk there. It's just over time, how big a risk does it manifest to be of concluded cases coming back to try and claim the costs back? I mean, if you look at it from an objective perspective, if you walked into a law firm with one of these cases, you would be advising the client that it's a strong case. You have a Supreme Court judgment determining that these concluded agreements, are unenforceable. They are for usually substantial amounts of money. and they would be against a well-capitalized defendant, being the funders in this case. So they are viable claims. If I'm being sanguine about it, I think like Tex was saying, one hopes that there is a high degree of goodwill between the parties, given they were presumably had an outcome they were satisfied with, either having succeeded at trial or succeeded with a good settlement. But I do think directors of companies that have had a settlement at least probably have a fiduciary duty to at least consider whether they should seek any redress. Now, considering it is not the same as actually launching a claim and issuing a claim form, but we will see as time goes on what appetite there is for pursuing this. I think Tetz mentioned the possibility that a defence for the funders will be to say, well, there is potential quantum merit claim here. In essence, that is where there's not been a contract or found to be unenforceable, or it's not been eventually signed. The courts can award as an equitable remedy a fair amount for the work done. And that alone might be enough for clients who are considering taking action to think that this isn't necessarily a walk in the park. There is a viable argument here of why funders should keep at least some of their remuneration, if not all of it. So what appetite to actually issue claims remains to be seen, but I certainly think we will certainly see at least investigations of what's possible.
Yes, very, very interesting points. I suspect that despite the fact that we all hope that there's goodwill and integrity out there, there will nonetheless be opportunistic moves made to see if money can be recouped, or if some sort of renegotiation can be achieved. So I think watch this space is my view. There's certainly a lot of buzz in the industry and people I'm hearing saying they're going to look at things, see if renegotiation is possible, see if there is a possibility of recouping some of the money paid over already. So we'll have to watch this space. But given all that, you would imagine that funders that have got a predominantly UK-based investment concentration might be fairly concerned at what's going on here. And I suppose you could look at this almost as being the potential for a Brexit of the third-party funding industry. Funders looking at it at the moment with capital to deploy, why would they want to invest in something that is perceived to be even more risky than it was already because of this particular issue? So, I mean, Nick, you are looking at funding cases worldwide. Presumably, off the back of this, you're going to have more of an appetite to look at funding in other jurisdictions, aren't you?
I'm not sure that's right. I think you can say there are challenges, but complying with the DBA regs isn't actually that difficult as long as you're sensible about it and you do what's required. I suppose it's the uncertainty. To the extent that there are challenges, it's the uncertainty. What else is going to happen? We don't know quite how this is going to pan out. Is it actually free and clear to use a multiple, or does that get caught because it's simply a way of calculating whether the damages, calculating the damages? I think we've convinced ourselves that it's only the percentages-based agreements that are a problem and that needed to comply with the various regulations, but opportunistic defendants may take a different view. There are opportunities for litigation finance globally. That's one of the things that's great about it. And there are opportunities in a range of jurisdictions, but there are significant numbers of potential investments in the courts of England and Wales. And I think there will be some reticence. And I think it's fair to say that funders that are not predominantly based in the UK either will or have reviewed their position. I think I've heard several US funders saying for the time being, maybe England and Wales is not a place for us to make investments. That said, there will always be opportunities, and I think certainly from my own personal perspective, whilst there are opportunities globally, England and Wales still remains an opportunity. We just have to tread very carefully, take good advice. And one might then say, well, everybody took advice already and this is what's happened, but and that's probably a good point, but the reality is there are opportunities in England, and I don't think we'll walk away from them just because of this decision.
Well, Tetz, you would, I assume, agree with that, because as I understand it, Lionfish does have a predominantly UK focus. How are you viewing this?
Yeah, no, I agree with everything that Nick said. I mean, I think, the reality is financial services industries, of which litigation funding is one of them, tend to adapt very quickly to the regulatory and the kind of commercial environment that it operates in. I mean, yes, obviously there are risks. I mean, there is a big debate potentially about whether multiples get caught. There are arguments to say like it's taken out of the damages, so that is no different than taking a percentage share. Others will say, but you know, CFAs are also taking share from the damages and they're multiples based, but they're not caught by DBA regulation. So there are a multitude of arguments, and I mean, certainly they kind of, you know, may kind of develop. I mean, there is a kind of a bigger picture thing I think we tend to overlook, is that the DBA regs, pretty much from when they first came into effect in 2013, have been have been kind of troublesome for many because it's been quite unclear. And one of the things that hasn't been very clear is whether LFAs were captured by DBAs or not. And so there have been two reform projects in the DBAs. 2019 generated the draft DBA regs for 2019, but there was one earlier in 2015, and the working group for that actually spoke to the Ministry of Justice, who said that the LFAs were not intended to be captured by the DBA. So, you know, going all the way back pretty much from the beginning, there has been this kind of need and this kind of sense that maybe the DBA regs just need to be, you know, clarified. So there is obviously, you know, the scope that things may change here. It's not to say that we should live in hope for it, but there is a genuine, you know, this hasn't been an issue that's suddenly cropped up today or this year. You know, LFAs being caught by the DBA regs has been in the thoughts of many for a long time. So, you know, the environment may change. I mean, do you make an investment decision when you're predominantly UK based not to continue because of that? No, you do. But I mean, if you're a US fund, you know, do you look elsewhere? Yeah, probably for now, because it's an unknown risk. And you know, why take an unknown risk when there are other jurisdictions they can focus on? But I agree with Nick. I mean, you know, the market is big still here in the UK. People need funding, and I don't think that that's going to stop the growth of the market over here.
Well, that's good to hear, because I think all of us recognise that there are some really good opportunities in the courts of England and Wales, and it would be a great shame if those opportunities were denied funding and access to justice because of these regulations or this ruling. We've been talking predominantly about, I think, single case funding, but I wondered, Neil, whether you might have a view on whether this has any implications for portfolio funding, where a funder is essentially providing funding to a law firm, which can then go out and offer DBAs to its various clients in the portfolio. Do you see any issues there?
I see it. I don't really see it as being particularly affecting that area as much. I think it's really a single case substantive issue, because these are cases where the funders were directly taking a percentage from the client's damages. If they're providing funding facilities to law firms, those law firms could then go and enter into their own DBAs or their own conditional fee arrangements. Most solicitors will choose to do a conditional fee arrangement over a damage-based agreement anyway. The economics work better. I think that's a very difficult, easy switch for them to make if they're not already doing that. So I don't particularly see it impacting portfolio funding as much as the single case funding.
Yeah, no, I mean, that's my view. Obviously, being a bit of an advocate of law firm portfolio funding, I think that's absolutely right. I don't see it having any impact at all. Obviously, then you've got to rely on the law firms getting their own DBAs right, but they do have quite a lot of experience in that so far. Obviously, if you're talking about other jurisdictions, particularly in the US, you know, contingency fee agreements, DBAs, as by other names, are very, very common. So I don't think it's going to have any impact there, but I'm interested to see whether maybe this will drive more interest towards portfolio funding to law firms to get over this single case issue. But that again is something that we might look at going forward. So what I think is very interesting now is that if you're a litigation funder, how are you going to structure an LFA going forward so that you know that it will not fall foul of these regulations? I'll ask you this to start with, Ted. So you're looking at a project at the moment, looking at a funding opportunity. Based on what's happened, how are you now going to change the way you structure those agreements? Are you going to look at a different type of pricing structure? Are you just going to forget about percentages completely and go to multiples? How are you going to do it?
I mean, we've actually always been very focused on multiples rather than the percentage share of damages. I mean, there are certain types of cases where a percentage share does make sense, but generally they tend to be, I would say, in kind of group actions where if you're trying to do a book build, working to a percentage share of damages is actually very helpful to doing a book build. But I mean, largely speaking, we've been very multiples focused, and I think, you know, LCM. The day after the judgment came out with an RNS saying that as well. And I think the market has generally been focused a bit more, has been moving a bit more towards multiples anyway. So, I mean, from our perspective, it doesn't really change it. I suspect that we'll see one of kind of a divergence, and not necessarily by firm, but just by case types, and also by strategies within people's kind of broader firms and funds, is those that just go purely multiple based, and then those that go with DBA compliant LFAs, taking a percentage share of the damages. You know, it's not actually a dramatic change from, I think, you know, what people have been doing. I think the only difference is those who used to go for the greater of model, you know, they'll just pick one or the other in which regards they go. So I don't think it dramatically changes actually how most people operate.
Okay, so you've basically been a proponent of the multiples based pricing structure for a while now. But Nick, you said earlier on that it's not actually that difficult to frame an LFA, so it is DBA compliant. Can you just give us your thoughts on that?
Yeah, I think the challenge is more, it's not necessarily complying with the regulations, it's more about whether or not the funder return is going to be satisfactory if you wanted to go down the percentage route, and limiting it to include all the various aspects under the regulations that cover the 50% cap at first instance. I think Tex is right that there's been a growing trend over the last number of years to move towards multiple based pricing. There was certainly in the initial days, the percentage was much more prevalent, and then we sort of moved to the greater of. But over the last 4 or 5 years, there's been a number of pushes towards doing multiple only based pricing, which obviously wouldn't be caught by necessarily by these regulations. The issue with the DBA regs is obviously the cap at 50%, including VAT and all disbursements, etc. But then I think it's regulation 3C, which provides that you have to explain the pricing that you're adopting in terms of telling your client why it is that you've set the price as you have. That isn't, in my view, terribly difficult, because that was something that was required under the old CFA regulations back from under the Wolf reforms, where when you originally started using CFAs, you had to use a risk assessment and put it into a schedule to your conditional fee agreement to explain why you were charging the percentage uplift on your fees that you were. So all funders carry out risk assessment. It's the core of what they do in terms of underwriting and attempting to assess the risk in a piece of litigation or a dispute. So putting in headline reasons as to why you're pricing the transaction the way you are shouldn't be terribly difficult. That said, of course, given what's been going on, prudence might suggest you probably stick to a multiple based agreement in any event. But hopefully that goes some way to asking what you asked me.
Yeah, I mean, Neil, do you have any views on that? Because actually, 50% cap is a relatively full cap, and most funding agreements that I've seen and negotiated in the past the percentages are well below that. So, what exactly is the issue here?
I think the probably elephant in the room is that your 50% cap is net of the costs. That can make a very substantial difference, particularly in long-running litigation. Not insurmountable by any stretch, but it is, I think, you say 50% on the top line. Actually, when you think about it, including the costs awarded, it is a substantially lesser return. But it clearly can be still operate functionally, economically, and profitably within these restrictions, or it sounds clear from the panel that there are multiple funders operating perfectly profitably within a multiples framework as well. So I don't see it stopping firms continuing to make profitable investments in meritorious cases. I think really it is actually the argument of it being a competitive disadvantage, unfortunately, for the UK in an industry where we were one of the global leading lights when it is a market for global capital, the fact that we have a more restrictive, not a terminally restrictive, but a more restrictive investment environment than other jurisdictions does, I think, suggest that capital may go elsewhere. If there's good claims, they'll still be invested in, but it just puts the UK at a less advantaged position than it was, what we all thought it was 2 weeks ago.
Yeah, no, that's very interesting. And one final point on pricing, because I know that this is pretty standard in any LFAs, that the funder, as part of the waterfall, is normally going to want priority to get its capital back at the very least, and that sits right at the top of the waterfall. Nick, do you think this ruling has any impact on that? Everyone's still going to be okay to achieve that, or do you have other views?
No, I think that's right. I mean, fundamentally, the funder is at risk. They put the investment in to ensure that the litigation of the dispute proceeds. They should want their money back first. I don't see that any funder is going to want to change that, and to the extent that there's a challenge to it or nobody wants to agree that, then it simply won't get funded, because we're supposed to be prudent managers of capital, and frankly, that's a very prudent move on the part of the investor to get their cash back out first. So no, I don't think there's going to be any change. I think that will remain the status quo.
Teds, would you agree with that?
Yeah, no, I would agree with that. I was actually going to say, when you were saying that question, I thought you were going to point it more to the direction of kind of actual kind of pricing, pricing levels, and whether this judgment had an impact on pricing levels. I mean, I think the two potential side effects that we've covered in this are the fact that there's a great unknown risk, and invariably, whenever you look at any pricing, the unknown risk is always the most expensive part. I think the second part is with less players in the market, just basic economics of demand and supply would suggest that pricing would go up as well. I mean, I think on an academic level, at least, the risk premium for litigation funding in the UK has gone up because of the PACCAR judgment. I mean, there is a, I mean, to be very cynical, I mean, there is probably a view of Britain at the moment in terms of litigation funding, which is not particularly favourable, and that certainly doesn't help. But I think, in practical terms, whether it translates through or not is another matter. But I think, in terms of pricing levels and in terms of waterfalls, it will be a slow evolution of things as they would have continued, whether PACCAR had happened or not.
Okay, so just as we're running out of time, I've got two final questions, the first of which I'm going to ask Neil. Do you feel that, given what's gone on here, and obviously there are uncertainties, and the industry could well do with some support here, is there a role that the Association of Litigation Funders in the UK and obviously ILFA more globally can play here to support funders and perhaps carry out some sort of lobbying role or whatever?
I think without a doubt. I do think that if there is a silver lining to this judgment, it is perhaps focusing minds on actually the benefits of potentially a robust, reasonable regulatory framework. Of course, new industries enjoy a period of time where there is less regulatory scrutiny as a burgeoning industry, and that can be advantageous, particularly for new starting industries. But the disadvantages can also become manifest in time. I do think the regulatory framework, or rather the legislative framework we currently have in place, is frankly a mess, and is a patchwork of statutes that, in my mind, are not particularly well suited to third-party funding and do put the UK at a disadvantage. And I do think this is a case where we should consider lobbying to get a robust framework in place that would, if anything, increase confidence to investigate in the UK in the industry. And that in itself also comes with uncertainty, because funders will think, how long will we need to comply with these regimes before there's a change, or will there be a change? But I do think it's investment that would benefit the industry long term.
Yeah, I mean, my personal view is that this really is an opportunity for the ALF and the ILFA to step up I mean, the author's been doing some really good work recently, I think, in providing lobbying for the industry, and I think about Alf as well. So I think really this is where the industry is looking for its trade associations to support and help it in what is, clearly quite a difficult time. And I suppose my final question to the panelists before we close off is, again, given all of this that's going on, I was at the ILFA conference in New York last October, and there was certainly talk about possible consolidation in the industry and some funders perhaps being swallowed up by the larger, more well-capitalized funders. Do any of you see, and I'll throw it over to Nick first, that this might precipitate that? Is this the sort of storm that creates consolidation in an industry like this?
Well, I think the answer is possibly. There are going to be some challenges for some funders, and I don't want to be a doomsayer, and I don't want to be sort of suggesting that this is the end of the world for litigation finance, because I think this panel has concluded that actually it isn't, and subject to some certain challenges in relation to maybe historic cases, then things should settle down. The reality is that there are funders out there who have been focused on the UK market predominantly, and who have financed their cases on the basis of percentage-based returns. And there's no getting away from the fact that lawyers will be asked to review those agreements, and there will be challenges. And that means that there will be funders who may be asked to repay certain amounts of money, and that could present significant difficulties for certain funders. Added to that, there's the disruption that we've talked about, and I think we've acknowledged between us that there will be disruption and attacks, and that can be a distraction, and that might cause some problems. So I think the stark reality is that yes, there might be some casualties, and that might result in consolidation prior to that casualty happening. But so as I say, I don't want to be a doomsayer, but we have to be realistic. There will be some problems.
Tets, what is your view on the industry going forward? Do you think it needs consolidation, or do you feel it's well structured as it is?
I mean, I think everyone's been talking about consolidation. I mean, I think there's certainly a lot more scope for evolution, with a lot of funders concentrating on very similar strategies and very few concentrating on opportunities outside. I mean, to answer your direct question, which was, does this judgment have an impact? I think this judgment is actually relatively small in the overall growth of the industry. I mean, it's one jurisdiction. It seems it's largely navigatable. So, to the extent that in itself triggers consolidation, I'm not sure, but I think there are other fundamental issues in the industry, not necessarily legal issues, but just commercial issues of how operators are structured. I think all of those are still set for evolution. I mean, just to tie into, I suppose, just to the point about regulation and kind of the industry going forward. I mean, I always think the most comparable asset class to litigation funding is actually commercial real estate. Commercial real estate is an unregulated industry, but it's an enormous industry. I mean, it absolutely dwarfs litigation funding, but it is between professionals, and commercial litigation funding is a professional to professional, largely professional to professional kind of industry. And one of those, I think, one of the key drivers of that therefore means that there's always going to be a few idiosyncrasies along the way. There's always going to be evolution. People will come, people will drop, strategies will die and then kind of rise again. And it's kind of like a constantly evolving beast. So I mean, consolidation may happen, but I think that'll just be something that'll be happening over a period of time. And as consolidation happens, so new players will also come in.
Okay, great. And Neil, final 30 seconds. Do you see any consolidation or direct impacts on the consolidation piece from this judgment?
In the industry, it really is one for the funders. As a lawyer, I'm not too sure. I suspect there will be anyway. I think this judgment comes at a time which is difficult for all financing anyway, given the larger macro environment. So it's perhaps unfortunate timing. But the hardest knives are forged in the hottest fires, and I do think you will see, as text says, not just consolidation potential of the industry, but actually funders looking at where they can best add value, such as portfolio funding or other strategies, so that they have a proper niche in the market rather than, as Ted alluded to, them following similar strategies. It may lead to some of that, but overall, it's not terminal for the industry by any stretch. It is a bump in a road that is inherent in a growing industry. But I do think regulatory clarity would help the industry a lot. There is a lot of useful, I would say, ammunition perhaps for IFLA and ALF in Lady Rose's dissenting judgment and in previous judicial comments, making a well-worded judicial criticism of the current legislative patchwork we have in the UK. And I think there could be very good arguments put forward to a government that I hope would be, and I think would be sympathetic to hoping this industry continues. London is a legal and financial capital of the world, and this is an industry that sits at that nexus and not something we want to see being uncompetitive. And so I think long term, there is nothing particular to worry about.
Yeah, I think that's absolutely spot on. My last comment is I do think this could be a catalyst for further interest in portfolio funding as the industry evolves. But we are just over 45 past the hour. So John, I think we've probably exceeded our time limit, and I'll hand back to you.
Thank you so much, Peter. Appreciate that. And we hope you enjoyed this discussion. We've got a range of perspectives here, which is great. That's a very timely topic. So I want to thank our panel for that. I apologize for the technical issues here, and I understand there's no question and answer, but all registrants will receive a recording of this event. So with that, I want to thank our moderator, Peter Pettit, did a fabulous job getting us through the entire agenda today. That's the plus side. Thank you, Peter. And again, big thank you to our entire panel, Nick Rolls-Davies, Ted Ishikawa, and Neil Johnstone. Thank you all so much. It's great to get your perspectives on this issue, which everyone is talking about. And if you are interested in past conferences, we have those available on our website, along with all of our daily reporting on the industry. Please visit www.litigationfinancejournal.com for more information. So thank you all, and we hope to see you at the next event. Take care, everyone. Have a great rest of your day.